Step 2. And this is where people get a little bit confused, especially if they're not dealing with or working with a lawyer who's helping them, because it is not common sense. How do you know what the next steps are? I will let you know that we do have resources available. And for those of you listening today, we're going to be sending you some of those resources about what step 2 and 3 and 4 and 5 and 6 is. But step 2 is to notify people and entities that the law requires you to notify. So now that you have an order signed that says you're the personal representative, you have 20 days to provide notice of your appointment to each individual who is named in the will as a beneficiary. You are also required to give notice of the probate to people who are the heirs at law, even if they don't receive anything under the will. The reason the law requires that is so that the people who are the heirs at law, but they are not receiving anything, have the opportunity to challenge your appointment as personal representative and the will itself. Sometimes will challenges happen because the will was fraudulently obtained at something called undue influence. It's to ensure that if anybody is interested and knowledgeable about this will, and they know that it was procured through undue influence, that they have an opportunity to challenge it. So this giving the notice is a great way to make sure that this is out on the table. If you're going to challenge this will, you've got to bring that challenge on right away. So you need to give notice of your appointment as the personal representative of the decedent's estate. In addition, you're going to need to notify some government agencies. In the state of Washington, it's going to be the OFR, the Office of Financial Recovery, and the Department of Revenue. Why would you have to notify them of the probate? Because there may be claims that the state has against this estate. For example, if the person who passed away was a Medicaid beneficiary receiving long-term care benefits, and let's say they were a single person, they still owned their house was never transferred or protected through estate planning, then what's going to happen is the state's going to have a claim to be reimbursed for the benefits that it paid. So giving notice to the state departments is a way that the state says, do we have a claim against either the decedent or possibly against a beneficiary? Maybe there's child support that would be due, for example. So you have to give notice to the state agencies. So that is step number 2. Right away, after you've been appointed, give those notices to the beneficiaries, to the heirs at law, and to the state agencies that you must, under the probate laws, give notice to.